Senator Kennedy began with a warm greeting. "Good afternoon, Judge," he said, smiling. Judge Thomas replied politely, "Thank you, Senator." Kennedy moved to a loaded question. "Judge, do you believe our criminal justice system is systemically racist?" The room froze. A yes could brand her an activist. A no could alienate supporters. Judge Thomas paused, then answered, "Senator, data shows disparities in the system. Certain communities are disproportionately affected." She avoided the phrase systemically racist, focusing on facts. Kennedy pressed, "That's not what I asked. Is the system at its core racist, yes or no?" He wanted a headline, not nuance. The tension mounted. Judge Thomas stood firm. "My role as a judge is not to make broad pronouncements about society. I look at the facts of each case." She deflected, returning to her judicial role. Kennedy grew frustrated, but Thomas refused to be cornered. Her restraint was clear. She would not be drawn into a political debate. The exchange was tense, a high-wire act. Every word was calculated. Kennedy sought simplicity. Thomas insisted on complexity. The stakes were personal and political. The room watched, breath held. Thomas's approach careful, measured, judicial. Kennedy's relentless, demanding, political. The moment revealed the pressures nominees face. Thomas's composure was her shield. Kennedy's persistence, his weapon. The tightrope walk continued. The hearing moved forward, the tension unbroken.
Thank you, Mr. Chairman. Judge, congratulations. I'm not going to ask you to comment on any Supreme Court precedent or how you're going to rule on cases. I just want to try to, as Senator Durbin suggested, get to know you a little bit. You serve right now on the Los Angeles County Superior Court. Is that right?
Yes, it is. Thank you.
Is the Los Angeles County Superior Court, in your opinion, systemically racist?
Thank you for that question, Senator Kennedy. So I think that questions regarding racism, regarding systemic racism, again, are very important ones for policymakers to be focused on. I'm focused on my day-to-day work as a judge on the cases that come before me, and I think that I best serve my duty as a judge by keeping that rigorous focus.
I'm sorry to interrupt you, but we have so little time, and I've got several questions. Do you consider the court to be systemically racist? Do you sit on it right now or not?
Again, Senator Kennedy, I feel that I best serve my duty as a judge by focusing on the individual cases that come before me, individual questions.
But the court is an institution. Do you is it? I mean, I think it's a pretty straightforward question. Is it systemically racist or not? The Los Angeles County Superior Court.
I understand your question.
Kennedy shifted tactics, launching his legal pop quiz. "Judge, can you tell me what the Erie Doctrine is?" A first-year law school question, basic but high stakes. Judge Thomas hesitated just for a moment. The camera zoomed in. Was it nerves or caution? Kennedy watched, sensing vulnerability. After a pause, Thomas answered, "Senator, the Erie Doctrine comes from Erie Railroad Co. v. Tompkins. It means federal courts in diversity cases must apply state substantive law." The answer was correct, but the hesitation was noted. Kennedy pounced. "It took you a while, Judge. That's a basic concept for a federal judge, wouldn't you agree?" He questioned not just her knowledge, but her readiness. The exchange was uncomfortable, raw political theater. In televised hearings, performance can matter as much as substance. Thomas's composure wavered, but she recovered. Kennedy pressed his advantage. The room felt the pressure. The pop quiz had exposed a rare moment of uncertainty. The hearing pressed on. The tension escalated. Kennedy's frustration was obvious. He wanted direct answers, not careful evasions. His tone sharpened. Questions grew shorter. "Judge, I need a straight answer. Yes or no?" The friendly Southern charm was gone. Now he was a prosecutor. He lectured on judicial clarity and transparency. "People are tired of nominees hiding the ball. They want to know who you are." Kennedy saw her caution as concealment. Judge Thomas stayed calm, answering, "Senator, I must follow the Constitution and Supreme Court precedent. My personal views have no place in my courtroom." She stuck to her message neutrality, not politics. The contrast was stark. Kennedy's impatience versus Thomas's restraint. He demanded simplicity. She offered nuance. The clash was about more than one nomination. It was about the role of judges in American life. Politics craves clarity. The law requires complexity. The hearing became a microcosm of that conflict. Thomas's consistency was her strength. Kennedy's passion, his. The room was divided, the stakes clear, the drama was real. The hearing pressed on, unresolved. The collision of worlds continued. Kennedy changed tactics, moving to policy.
But I think that those kinds of questions are best left to policymakers, and that as a judge, that what I need to do is
Okay,
to focus
I
on my
understand.
cases.
You don't want to answer it, I get it. Explain the Erie Doctrine to me. You're going to see that a lot on the Ninth Circuit.
Thank you for the question, Senator Kennedy. Now, in my 14 years as an attorney, as appellate advocate, having handled many different cases, I never had a case regarding the Erie Doctrine. I'm sure I learned about it in law school.
Yeah.
I don't recall it sitting here before you now, but I'm certain that I'd be able to look it up and find the answer for you and come up
Are
to
you
speed.
familiar with Erie v. Tompkins?
I am familiar with the existence of the decision. I'm sure that I read it in law school. I haven't read it recently.
Okay. All right. Name a public policy that you think is a good idea but is unconstitutional.
Thank you for the question. Given that I am a sitting judge and a judicial nominee bound by codes of conduct, I don't think it would be appropriate for me to comment.
Judge, what are your views on universal basic income? It was a trap. No right answer for a nominee. Thomas replied, Senator, that's a policy question for Congress. As a judge, I interpret the laws Congress passes. Kennedy pressed, but you're a citizen. Don't you have an opinion? He tried to frame her neutrality as evasive. Thomas stood firm. Every citizen has opinions, but a judge must set those aside. My duty is to the law and the facts. She reinforced her core message, impartiality. Kennedy tried to make her seem secretive. Thomas turned the question into a statement of principle. If a case involving that policy came before me, I'd rule impartially. Expressing a view now would compromise that. Her answer was disciplined, unwavering. The exchange highlighted the tension between political demands and judicial ethics. Kennedy sought transparency. Thomas, neutrality. The hearing was a test of both. Thomas's resolve did not crack. The message was clear. She would not be baited. The hearing moved to its final round. With time running out, Kennedy asked about universal injunctions, a complex legal issue. Is it appropriate for one district judge to issue a nationwide injunction? This was a chance for Thomas to show her expertise. This time, she was ready. Senator, it's a profound question. There are strong arguments on both sides. Proponents say it's necessary for complete relief. Opponents worry it gives too much power to one judge. She continued. The Supreme Court hasn't definitively ruled. As a lower court judge, I'd follow my circuit's precedent and Supreme Court guidance. Her answer was confident, nuanced, and detailed. It showed respect for the judicial hierarchy and the complexity of the issue. This was a moment of recovery after earlier stumbles. Kennedy had no follow-up. My time has expired, Mr. Chairman. The showdown was over. Thomas had survived the grilling. She maintained her composure and principles. The contrast between her restraint and Kennedy's persistence defined the hearing. The nation had witnessed a revealing test of character and philosophy.
On policies that I believe are constitutional or unconstitutional.
No, I'm not asking to do that. I'm saying, tell me a policy that you like that has already been declared by the courts that's unconstitutional.
Thank you, Senator Kennedy. So I, as a judge now, and again, if confirmed, am bound to follow Supreme Court precedent. I'm bound to follow Ninth Circuit.
I know
precedent.
that, and I'm running out of time. And if you don't want to answer, I get it. I've got other questions.
Well, it's not, I'm sorry.
Can you name me a public policy? I'm not debating the legality of it. I'll stipulate that it's unconstitutional, or that you think is a good public policy regardless.
Well, thank you. But in my view, I am not served, and my oath is not served by me commenting about my personal views, because my personal views don't drive what I do as a judge, which is to follow the law in every case without reservation, whether I think something is a good or a
I'm
bad
running out of
policy.
time, Judge. I still don't understand any of your answers. Let me try one more. Here's a hot topic. tell me the legal basis for a universal injunction.
Thank you. So injunctions are governed by Federal Rule of Civil Procedure 65. The court has said that injunctions are an extraordinary remedy, and I understand that they are. So the legal basis for a universal injunction or a nationwide injunction is whether it is necessary to give the plaintiffs complete relief, but without imposing an undue burden on
Is that case law or constitutional law?
That's case law.
And what's the cases? What are the cases?
I can't cite for you the specific case, but I've reviewed cases about universal injunctions and understand again that that's an extraordinary remedy, very fact-bound determination about whether those should be issued.
Okay. Thank you.
Thank
Mr.
you.
Chairman.
What kind of judge would Thomas be? The answer, for now, was in her poise under fire.